So this video is going to take you through how to approach a diminished responsibility scenario. Diminished responsibility, you might see it written as DR, is now under Section 52 of the Criminal and Justice Act 2009, and it is a partial defence to the offence of murder. If successfully pled by the defendant and the burden of proof is on the defendant to prove it on the balance of probabilities, then it will allow the judge to not give a mandatory life sentence, but the sentence is at the discretion of the judge. So the scenario we're going to use, and I'm going to say straight away, it's a murder scenario, so of course it's unpleasant, but this one has some particularly triggering things. So the scenario we're going to look at, we're advising Ezra on her potential criminal liability. She's recently given birth in circumstances of secrecy. She's suffering from stress and postnatal depression. She goes to visit her Aunt Rena. Rena isn't sympathetic, criticizes Ezra. Ezra gets angry, grabs a pair of scissors and stabs Rena to death with it. And we're going to use our state, explain, apply model. So first of all, we're going to state Section 52(1), the defendant has to have an abnormality of mental functioning. And we're going to explain it using the case of Byrne. Byrne was from 1957, and you have to bear that in mind when we look at the terminology. So we're looking at mental functioning is abnormality of mental functioning is a condition so different from that of an ordinary man that the reasonable man would term it as abnormal. And you must use the wording of the case. So clearly Ezra would be termed as abnormal by the standards of the reasonable man. Next up, Section 52A, the abnormality must arise from a recognised medical condition. And again, we have some old law here. Speak uses the term mental deficiency. By that, in modern terminology, we're talking about any sort of mental health issue. Gittins, chronic depression, aloalia, battered women syndrome. And we're also going to state that proof is needed and explain the case of Campbell, which states that medical evidence is required. And we can apply this by saying postnatal depression and the anxiety that she was suffering is a recognised medical condition. Medical evidence could be sought to prove that Ezra was suffering at the time. So they don't need the diagnosis before, as long as you could secure a diagnosis after the fact. We're then going to move on to state Section 52(1)(a). It's got to substantially impair our defendant's ability to do one or more of the following things: understand the nature of their conduct, form a rational judgment, exercise self-control. And we can explain this with the case of Egan, that says that a substantial impairment is more than trivial, meaning it has no impact, but less than total, where it rules every aspect of our defendant's life. And we can apply that by saying that it would appear that the postnatal depression may be impairing Ezra's ability to exercise self-control, stop herself from lashing out. And finally, we have to state Section 52(1)(b), the abnormality of mental functioning has to provide an explanation for our defendant's conduct, or at least be a significant contributory factor. And we can explain that it's got to be either the main cause or one of the main causes. And we can apply this by saying that without the postnatal depression, Ezra would not have killed her aunt, and therefore the abnormality does provide an explanation for her conduct. It provides the explanation for the killing. And therefore you can state that Ezra is likely to be able to use the partial defence of diminished responsibility, and therefore is likely to have a partial defence to murder, meaning that her sentence would be at the discretion of the judge.